This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning. I'm Stuart Address, and this is Ask a Lawyer for December 6th, 2019. We're almost at 2020, where foresight will be as good as hindsight. 2020.
Oh, okay.
Jeez.
Oh, okay. I'm slow today.
Started with a flat one there.
Oh, no, it was very good.
Well, folks, I wasn't here last week. I want to explain. I decided to get into shape, about a month ago. I'm a couch potato. And decided wanted to be able to walk places and do some things with my son and my girlfriend. So I hired a personal trainer to come to the home. Well, after the first hour, the first session, I found my feet sore the next day, and I figured, okay, that's to be expected, pretty normal. Didn't really get better. That's a little bit more worrisome. So finally I go to the podiatrist. He says, well, you probably have tendinitis, and, gives me a conservative treatment. Doesn't get any better. So I go back and he schedules an MRI, which I had this past Tuesday. And turns out I have a partially torn tendon in my foot. So much for couch potatoes trying to exercise and get walking again.
Well, we got plenty of those boots over at IRSC basketball. So
yeah, I've been from the walking boot now to a soft cast, and it may next week be back to the walking boot because it provides more support. But I will be more mobility challenged than normal for the next 2 to 3 months. And last Friday, I was just in too much pain.
Yeah.
So I was not here. So you got to listen to the rabbi, and I hope that was enjoyable.
Yeah, actually, she was very, very good. On the foot, you think about that. And, of course, we joke about Cliff being our bionic guy 2 weeks in after hip surgery.
Oh, gosh, I don't know. I would never do that.
But see, like Dr. Sellards always says on the Bone Talk show, the knee surgeries are far worse because that's weight-bearing.
And, so is the foot, let me tell you.
Exactly. It would be the same.
Anything I, get out of bed, stand up.
You betcha.
Everything. Even I try to put more weight on my right foot, you're still putting weight on the left foot.
Mm-hmm.
Anyway, so I guess I have to put my right foot forward.
Yes.
All right. Well, we do have an interesting topic for today that will probably take at least a couple of weeks. That's if we even get to it, because you can always call us here at 340-1590 and ask me whatever you want and, play Stump the Lawyer. I don't know the answer, if it's not in my area, I'll tell you that. If it is, I'll try to help you. Anything you want to ask, just give us a call at 340-1590.
Or you can play a politician and just make it up.
Well, I was going to say impeachment. It could have been a great topic for today. We could be talking about Article 2, Section 4. Everybody's learning about that. Everybody's learning about the emoluments clause. I got to give President Trump props. I don't think I've ever said that.
Well,
I've
got
to
get my heart checked.
There's somebody at the temple. If she's listening, she's probably having a heart attack right now. I've got to give the president props. He is the cause of people learning civics. We are learning about the Constitution because of him. The emoluments clause, I don't think the people on CNN, MSNBC, or Fox knew what that was before they had to look it up.
Can't even spell it.
I can. Article 2, Section 4, well, most people knew impeachment was somewhere in the Constitution. How many knew it was in Article 2, Section 4? I think almost everybody knows that now. But no, we're not going to talk about impeachment or Trump today. It would be fun, but I came up with something else.
That's good. Thank you.
Now, before we do that, though, I do want to tell an interesting story. One of the more interesting stories that has occurred in my career, one which could have got me into a lot of trouble if I was not careful, alert, and let's just say not too greedy. We had a submission through our website, contact inquiry. Normally, I can see I get one or two of these types a month, and they're bogus.
They're like phishing things.
You know, they're Hong Kong or China.
Yeah.
You know, I want to enforce a breach of contract, and you know, I usually forward an email, you know, to my paralegal. Back then, it was Cheryl, and I'd say, "Don't bother with this one. It's just, you know, scam." Well, we got one in this week, and I guess I wasn't in the office or what have you, and I did not forward that type of an email to Sadia saying, don't worry about it, just ignore it.
Uh-oh.
So Sadia does what she is supposed to do. She tries to make contact. The phone does not work, so she makes contact through email. And somebody responds, and Sadia replies that we need certain information and it would be helpful if they called. And that's as far as it went until Wednesday, when I walk into the office in the morning and Sadia says, I need to talk to you now. Something's happened. I go, okay. She says, we just got a check for $355,000. I said, what? She shows me this check made payable to my firm for $355,000 and $355,200.
Was it from the Ukraine?
No. It was from Holy Cross Hospital here in Florida. And it was written on a local bank.
Oh, God.
Payable to me.
Yes.
And it came with a cover letter from the director of Human Resources saying that this was a partial payment in a settlement with a former employee, a Dr. Let me see, I my glasses. Dr. Go Ka Hung.
Uh-oh. Oh, no.
And that another payment would be coming mid-January. Now, first of all, I never agreed to represent Dr. Go Ka Hung. I don't have a representation agreement. But apparently the letter said that Dr. Go Ka Hung told them that I was representing him, and so here's a check. Okay. Now, other attorneys have fallen prey, so I was aware of what was going on.
Cash that check. Oh.
Other attorneys now have deposited it into their trust account.
Yes, yeah.
You know, your bank makes the money available in 2 to 3 days, but that doesn't mean it's cleared the Federal Reserve banking system.
Right.
So the client contacts you and says, you know, give me my share, you keep your share. The attorney writes a check out of his trust account.
Oh, no.
And the next thing you know, 2 weeks later, it's bounced.
Scam.
Well, the problem is it's not just bounced, but now all the money that was your client's, that was in your trust account, is gone. Because you wrote money on a bad check, and so the money that was in the account was taken by the bank.
Why?
Because you bounced a check and they got as much as they could.
Oh, God.
So they don't suffer a loss. So now the obligation of the attorney is to self-report to the Florida Bar a bounced check on a trust account. That's number one. Number two, you then have to self-report that the money of all your clients, let's say 8 clients, 10 clients, 100 clients, has now been stolen because you basically spent it unintentionally, but you spent it without permission.
Oh, no.
Which is a breach of fiduciary duty.
Yeah.
Well, no matter how innocent you were in this, you're facing discipline from the Florida Bar and at least a short suspension. This is serious stuff. The Florida Bar does not take improprieties, no matter how innocent, in your trust account lightly.
Oh, no.
That's your client's money.
Well, yeah.
So this could have been very bad for me. But I sort of figured out what I thought was happening. And I said to Sadia, well, first, why don't we call Holy Cross and see if this is their check and if this is their employee, both the person who they're writing the check to or for,
Right.
and the person who wrote this letter saying, I'm here with Holy Cross Hospital. So Sadia does call Holy Cross. There is no such employee who wrote this letter.
Oh, boy.
There is no such employee ever that the money was for. And that's not their bank.
Oh, boy. Oh, my God.
So it's exactly what I suspected.
Boy, that's pretty elaborate, though.
Yep. So Sadia, at my direction, called the FBI.
Good.
Because it's interstate.
Yeah.
And
Where was this Holy Cross Hospital? Or several.
It was
obviously.
Florida.
It was in
Yeah.
Florida. Okay.
But the supposed Dr. Gung Ho Hung or whatever, this check was from Ontario, Canada.
Oh.
So the FBI directs her to fill out an online, complaint,
Oh, no.
which she does. Submits
We
it.
have an FBI office right here.
Right. Well, yeah, that's what she called. She called Washington. Washington wouldn't have answered the phone. They're too busy investigating, the Bidens.
Yes.
No, I'm joking, folks. Don't call me about that.
No,
please.
God, please, no.
So the FBI tells her that she should call the Department of Homeland Security
Yeah, I would.
because the Treasury Department is now part of the Department of Homeland Security.
I did not know
Or maybe
that.
it's not. But Treasury handles money. Anyway, she was
How
told to
about
call.
the Secret Service? Didn't
We're getting there.
they? Okay.
You're ahead of me.
Okay.
So she calls the Department of Homeland Security locally here in Florida. I think they're in Miami. And they tell her to call the Secret Service because we're dealing with a counterfeit check.
Yeah.
So she calls the Secret Service. Agent gets back to her. They take a complaint, but they tell us that they're really not going to do anything about it. And we're not the victim. Theoretically, the victim is Holy Cross Hospital, although I don't understand how they're a victim either because they didn't lose any money.
You would have been the victim.
I would have been the victim.
Yeah.
So Secret Service then tells us that we should contact the local police.
Yeah,
Okay.
the Bunko Squad, yeah.
So yesterday I see there is a police officer. I'm on the phone. I see there's a police officer, a burly one, in the office talking to Sadia. I could overhear what's going on. And she shows him the letter and the check and all of that. And he goes outside and he contacts Holy Cross Hospital and confirms that no such person, not their check. I think they were down somewhere in Miami. And he suggests to them that they file a complaint, Fort Lauderdale. They file a complaint with their local police department.
Good. Good.
So they do that. We now have a complaint with our local police department. He took the original check and the original letter as evidence. And I had Sadia prepare 1, 2, 3, maybe 4 memos to the file. Just in the unlikely event that one day somebody complains to the Florida bar. And I get one of these lovely Florida bar letters that says, a bar grievance has been filed against you. Pursuant to rule such and such, you have 20 days to respond. Well, at least now we have memos to the file that show contemporaneously what steps we took and what we believed to be true and why, which will certainly, protect me from any potential issues.
Could you go to the Martin County Bar and say other attorneys had better watch out for this?
Well, I think most attorneys get these types of inquiries once or twice a month.
God.
It's more savvy than I'm a Nigerian prince and I need you to help me. There are attorneys, I don't know if they're in Florida, but I have read other attorneys who have fallen prey and have had their trust accounts wiped out. But, I was told that I think the police department told us that these types of emails go out in the thousands, and they're just fishing for somebody to respond and take the bait.
That's horrible.
And even if they get a 0.1% sucker, that's where they make their money. So a very interesting set of circumstances in our office this week. FBI, Homeland Security, Treasury, Secret Service, and local police.
I got that Secret Service thing, by the way, by watching SWAT.
Right. So a little bit of excitement
Oh, man.
in the office. It'll be one of those coffee hour stories that I'll probably tell in the future.
That is very scary.
Just very fortunate I did not deposit that check.
Oh, yeah. Thank goodness for that.
End of the year, could have been a nice fee, no. I thank myself that I was a little bit more savvy. But, there is a real problem here. It's not just with lawyers. We get, everybody, so many phone calls and emails that are scams. And some of them are so sophisticated that some segment of the population reasonably falls for them. Very often they target the elderly. And, as you get older and sometimes lose a little bit of, your faculties, and, this is why there are statutes to protect the elderly.
You're looking at me now.
No, I'm not. You're not there yet. But sometimes you're tempted to at least give out a certain little bit of information before you get suspicious.
We get them from, like, PayPal, who we deal with.
Right.
FedEx,
Well,
UPS. I mean, it's like...
Let me give you all a tip.
Oh,
I showed this to my girlfriend over the weekend because she got a couple emails supposedly from her bank that she thought, are they really from my bank? If you go and click on the name of the person in the email who sent it to you, their email address will come up. And if it's Joe Schmo at abc.com, it's not from your bank.
okay, the name that's on the letter...
It may say customer service at
Right.
suntrust.com.
Right.
That's what it will say in the from. But if you click on that in your email, the actual email will come up, the email address.
I think Carol knows how to do it.
So now,
yeah.
what originally showed to you as customer service at suntrust.com may show to you Joe Blow at abc.corp.
Right.
Well, you now know that it's not really from SunTrust. Sometimes it's a little bit more sophisticated. It may be, customer service. You click on the little thing, and it says customer service at suntrust.il.com. The IL is the country Israel, as an example. That's not SunTrust. You got to look for those little variations.
Yeah.
And if you have any doubt, you don't click, you don't call the number, because that number may be going right to them, so that they can scam you. If, there's been a data breach and that's what you're being told, call us. And let's say it's SunTrust. Google and call the SunTrust 800 number.
Mm-hmm.
And tell them you got this email, and they'll tell you if it's them or not.
Yeah.
But don't respond to the email. And don't respond to the phone call. I heard somebody explain to me that there is a scam by telephone where they just want you to say the word yes. And once they have the yes, they use it to do all sorts of things. So, I could see myself falling for that myself. That's, is this Stuart address? Yes. Oh, they just got me.
Bingo. You know what I do when I answer my phone? I just answer it, this is Greg Wyatt. That's it. And then you can pretty much
Well, I start saying now, well, why do you ask? Where are you from? I think I hear a lot of noise in the background. Is that a call center in India? Oh, no.
No, it's Thailand.
Yeah.
Oh, boy.
And then again, as some people who know me, every so often I'm in the mood, I just toy with them.
Cliff does that all the time.
And at the end of toying with them, I'm sorry, this is a little bit graphic, but I, sort of when I really want them to hang up on me, as opposed to me hanging up on them, I just say, "What color's your underwear?" Usually that gets them to hang up.
That's it.
God forbid they respond, then this is not that kind of call.
Oh, my.
All right.
Then you know it's coming from Greenwich Village.
Well, maybe. Or San Francisco.
Or San Francisco, yes.
You can lose a lot more than your heart in San Francisco.
Yes.
In San Francisco, you're allowed to walk around nude.
Sure. Hardly.
No,
Really?
Yes.
That is...
Local ordinance.
Oh, boy.
You are allowed to walk around nude. You're not allowed to do things that are sexual in nature in public, but you don't have to be clothed.
All right. Okay.
Okay. All right. So, what did I want to talk about today that I thought might interest you all? Again, unless you want to call me at 340-1590. I have received an increasing number of calls regarding social media posts, and I got fired. This is happening a lot. And, it happens too with kids who are applying for college, and colleges now go to look at their social media, and, they're drinking or smoking pot or something, and you just screwed up your college admission. But let's talk more about this type of a call.
Or I've seen direct in the last year athletic scholarships that kids who were really good got blown out at the next level because of their stupid posts.
And you can tell them as much as you want, but they're still going to do it. And sometimes, I tell my kids, at some point you're going to pay the price for whatever you do. Whatever mistake you're making that I'm trying to teach you that, you won't be taught. You might make a mistake and it may cost you dearly, and I guess you'll learn your lesson at that point. My job is to try to help you learn the lesson early before it really hurts you. But there are plenty of people, kids, adults, have to learn lessons on their own. And sometimes things can cost you dearly.
Everybody's watching now.
So let's talk about social media. Does that mean that you as an employee cannot post anything on Facebook, Instagram, whatever the other apps may be, then anything can get you fired? No. Even though you're an at-will employee, it doesn't mean that. It means you should be really careful. It means that if, you are posting things that have public access, be really careful. Even if you're posting things that only go to your friends. If one of your friends is a friend with an employer or a supervisor or a manager, and they see it, you may have a potential problem. You must be careful. But over the last 8 to 10 years, cases have gone through the system with regard to termination for posting on social media.
I'm not surprised.
And in the last 8 to 10 years, the National Labor Relations Board, which is a federal agency, has also developed rules with regard to what employees may or may not post without possible adverse employment consequences, because there are some things that, whether you're a union or non-union, NLRB has laid out certain guidelines and courts have followed them that, indicate certain types of posts that we're going to talk about now that you can do and that you cannot be punished for. Now, that doesn't mean you won't be punished and then may have to spend 2 years fighting it and may cost you money. So, at the end of this, probably next week, in summary, I'm going to be telling you the wisest course of action is don't post anything about your boss. Don't post anything about your company. Just don't do it. Don't buy yourself a lawsuit. Because if you don't like lawyers, you're going to be living with them if your employer decides to do something, even if the employer is wrong.
And if NLRB gets involved, you know it's really serious.
Yes, so let's start with the NLRB. Okay, the National Labor Relations Board is a federal agency and is under federal statute and regulations through the Federal Code of Federal Regulations. And it not only decides administrative cases, but it also issues opinion letters. Like most agencies, Department of Labor issues opinion letters on overtime and wage and hour. And these things do not have the effect of law, but courts that are looking to how to interpret something, the case law says it gives the agencies great deference in their interpretations. All right? Because this is their job. So, what has the NLRB started to say? In 2010, it issued its first General Counsel memo. And actually, it's actually 2011, I'm sorry. And it was about 14 cases that had come up the chain administratively before it. And in 4 of the cases involving the employees' use of Facebook, the Office of General Counsel found that the employees were engaged in, quote, protected concerted activity. That's going to become a very important 3-word phrase. Protected concerted activity. We're going to define it. Quote, because they were discussing terms and conditions of employment with fellow employees.
Oh, okay.
Now, in 5 of the cases involving Facebook or Twitter posts, the activity was found to be unprotected. So if you're fired, tough luck.
Oh.
And in 5 other cases, some of the provisions of the employer's social media policies were found to be overly broad and not enforceable, but others were found to be okay. So, the second report by the Office of General Counsel was issued in 2012, the next year. It also looked at 14 cases, half of which involved questions about employer policies. So, you go to work, your employer has an employee handbook, has all these policies in there. Very often now you'll find a social media policy. That doesn't mean that social media policy is consistent with the law. It just means it's the policy that the employer has written, or some lawyer has written for the employer. So in this situation, 5 of the policies were found to be unlawfully broad. 1 was found to be lawful. 1 was found to be lawful after it was revised. And the remaining ones involved discharges of employees after they posted comments on Facebook. In those situations, several of the discharges were found to be unlawful because they flowed from unlawful policies that punished, what was that phrase I mentioned? Protected concerted activity. And the others were found to be activity that was capable of punishment by the employer.
Wow.
So now we hopefully you're all starting to wonder, what are the guidelines?
Those 3 words.
Okay?
Yes.
Now, the 2012 report had 2 main takeaways from it. The first is that employer policies should not be so sweeping, so broad, that they prohibit the kinds of activity protected by federal labor law, such as discussion of wages or working conditions among employees. The second is that employees' comments on social media are generally not protected if they are mere gripes made in relation to the employer or a manager or a supervisor. So now we're going to have to start defining gripes versus protected concerted activity.
Sounds like you're parsing the daylight.
This is why lawyers exist.
Oh, brother.
But we're trying to give employees protection in an at-will environment. Now, the third report was issued later in 2012. It examined 7 employer policies governing the use of social media, and in 6 of the 7 cases, the General Counsel's office found some of the provisions of the policies to be lawful and others to be unlawful. In the last case, the entire policy was found to be lawful. Now, how did the NLRB make these distinctions in general? Here's what it said. Provisions were found to be unlawful when they interfered with the rights of employees under the National Labor Relations Act, such as the right to discuss wages and working conditions with coworkers. So now, let's try to get into some real actual decisions so we can figure out what you can do and what you can't do, even though I just told you, if I were you, I wouldn't do it at all. All right. We have some early NLRB decisions. Remember, the NLRB is a federal administrative agency. It makes decisions as well. For example, if you're protected by a union, you may appeal to the NLRB. So, we have an NLRB decision.
I think our union in Los Angeles had them on speed dial.
Probably. All right, so let's see. The first decision, September 28, 2012. The board found that the firing of a BMW salesman for photos and comments posted on his Facebook page did not violate federal law. The question came down to whether the salesman was fired exclusively for posting for posting photos of an embarrassing accident at an adjacent Land Rover dealership, which did not involve the employee, or for posting mocking comments and photos with coworkers about serving hot dogs at a luxury BMW car event.
Okay.
The board, on an appeal from a decision of the administrative law judge, held that the salesman was fired solely for the photos he posted of a Land Rover incident, which was not concerted activity and so was not protected. End result, you're fired. Tough luck.
Ouch.
Now, in the second decision, December 14th, 2012, the board found that it was unlawful for a nonprofit organization to fire 5 employees who participated in Facebook postings about a coworker who intended to complain to management about their work performance. In its analysis, the board majority applied what it considered to be settled labor law to social media and found that the Facebook conversations were concerted activity and were protected by the NLR, National Labor Relations Act. Why? Because there was a discussion among employees about working conditions and an employee who intended to complain to management about them. So now you have a group of employees talking about working-related conditions. That is concerted activity, and so it's protected. Okay. So let's, keep on going in the chronology as we get to, present day, which we'll get to at some point. In 2018, the NLRB releases an advice memo from its Office of General Counsel regarding whether various employees at CVS Health were properly terminated based upon CVS's social media rules, or whether they were unlawfully overbroad.
Ooh, that's a big company.
Yeah, very big company. Well, so is BMW.
Well, individual dealerships, though,
Okay.
are a little different.
Now, the article I was reading about this explained that the memo from the Office of General Counsel delivered mixed news for employers, which is good for employees, although it's mixed news for employees too. The NLRB found that 2 of CVS's social media policies violated workers' rights under the NLRA. But the rest of the social media policies were lawful.
God. That's why you need a lawyer to go
The
through
unlawful policies impinged on workers' rights to discuss with each other, quote, wages, working conditions, or employment disputes, and to, quote, engage in concerted activities for their mutual benefit, end quote. Those rights were included in the NLRA to protect workers' rights to organize and to publicize what they saw as unfair, unsafe, or illegal working conditions. Now, one of the things that CVS got wrong, according to the NLRB, was trying to force employees to identify themselves by their real names anytime they discuss anything about the company or its activities on social media. You could be Bill's Cow Milker 12487 talking about CVS. CVS said, well, no, you have to identify yourself as John Smith.
Right.
NLRB said, no, 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 no. You cannot require your employees to have to identify themselves by real names whenever they talk about you. It's overbroad.
So I can't use Bill's cow milking anymore.
Oh, no, you can.
Oh, you can't. Okay.
They can't require to use John Smith. What the NLRB said was, quote, requiring employees to self-identify in order to participate in collective action would impose a significant burden on Section 7 rights. That's Section 7 under the National Labor Relations Act. But the board found no problem with CVS saying employees can't post material that's, quote, discriminatory, harassing, bullying, threatening, defamatory, or unlawful, or any content, images, or photos that they don't have the right to use, end quote. So we're getting more and more guidance as to where is the line. Not that in any respect in any laws there's ever clear guidance, that's otherwise there'd be no legal cases. Now, in 2017, there's a case, another large company, Boeing.
Oh, yeah.
And the NLRB recently issued new guidance regarding employee handbook rules as a result of the Boeing case in 2017. In Boeing, the NLRB overturned its old standard. Now, we've been talking about what the NLRB has said so far. The NLRB overturns its own old standard, under which an employer's rule violated the act if a worker could reasonably construe it to interfere with the right to engage in protected concerted activity. Instead, under the new standard adopted by the NLRB, an employer rule will only violate the NLRA if it would be reasonably interpreted to interfere with workers' NLRA rights, considering the balance. That's a balancing test, folks. The balance between A, the nature and extent of the rule's potential impact on protected rights, and B, the employer's legitimate justifications for the rule. Well, now we have more ambiguity. And now we have to have cases that define that so we understand the new rule better. Okay.
I think your initial conversation of just don't do it is.
See, I'm glad you're going there.
Oh my goodness!
All right, now the NLRA tries to help define this a little bit better. It defines 3 categories of employer rules. Category 1 rules are presumptively lawful. Category 2 rules warrant individualized scrutiny. And Category 3 rules are presumptively unlawful. So we assume lawful, assume unlawful, or you really got to look at the facts of the case.
Now, in the Boeing case, were they union employees? Because I would think the union would fight for them.
The union may have been. It may have been the union representing them before the NLRB and the ALJ, administrative law judge, and then appealing to the overall board
Okay.
It's very
gotcha.
possible.
Oh, yeah. Okay. Yeah.
So, Category 1, presumptively lawful. Employees may not comment or speak on behalf of the company without prior written approval. Makes sense.
ESPN was like that.
Employees may not make negative or disparaging remarks about other employees. Makes sense. Employees may not disclose the company's confidential, proprietary, or trade secret information. You better believe that makes sense. Even as an employee's attorney, that makes sense.
Sure.
Employees may not disclose information concerning the company's clients or customers. That makes sense
That makes
too.
perfect sense. Yes.
Employees may not misrepresent the company's products, services, or employees. And employees may not use the company's logo, trademark, or graphics without prior written approval. All those policies, if they are policies of an employer, the NLRB says are presumptively lawful. So if you violate them, presumably you have no recourse. It's goodbye, find another job. Now, Category 2 rules are fact-dependent, individualized scrutiny. What are some examples? A blanket rule that prohibits employees from making disparaging or negative remarks about the company. Well, if you're just making those remarks and you're griping, remember I used the word griping, we're going to find out that that's not okay. You can be fired. But if you're making those comments in connection with complaining about they don't pay us overtime or, they don't give us proper days off, that's going to be okay. Blanket rules prohibiting employees from criticizing the employer, same thing. Blanket rules prohibiting employees from making false or inaccurate statements. Well, I guess the problem is going to be what's false or inaccurate.
Yeah.
Blanket rules providing that wages, benefits, or working conditions are confidential or preventing employees from discussing them. Can't do that. That's a Category 3, presumptively unlawful. And Category 3, blanket rules prohibiting employees from joining outside organizations, like a union. Presumptively unlawful. Now we're beginning to define the parameters a little bit more, but hopefully by now those of you who are listening and haven't fallen asleep realize that this is not so simple. How easily do you all, including me, but thank God I'm my own employer, how easily do we post things on Facebook? How much thought do we give to what we post on Facebook? My mother complains that sometimes she learns of things in my life from Facebook. Well, Mom, I guess you can hold it against me.
Some things I couldn't
Use
tell
Jewish
you.
guilt, But I guess you can't take adverse employment action because I'm not your employee.
Oh, yeah.
But we post these things often without thinking.
Yeah.
When it comes,
Guilty as charged.
When it comes to posting stuff about your employer, be careful.
Yeah.
So 2019, a little bit later, now we're in this year. Almost not this year, but we're still in this year. The NLRB Office of General Counsel publishes a memo. It centers on the legality of the social media policy of Brighton Rehabilitation and Wellness Services. And it concludes, these are unlawful policies that the company has. Be honest and accurate contains an unlawful work rule. The board reasoned that requiring complete accuracy would have a chilling effect of keeping employees from engaging in discussions regarding the terms and conditions of employment out of fear that their statements could be challenged as inaccurate or incomplete. The added burden of having to verify accuracy could keep employees from speaking up in the first place.
I would think the word complete would throw that out.
Well, you publish something, you're
That's
probably,
like always.
You're probably not publishing a thesis and examining all sides of the issue and presenting all the facts. So what they're saying is, you can't have a rule that says everything has to be perfect. And, I mean, I guess we could combine CNN and Fox, and maybe we'll have a complete realm of information. I don't know. Maybe they'll just be yelling at each other. But this is a prohibited rule. The board also concluded that certain restrictions under the company's subheading, post only appropriate and respectful content, was unlawful as overbroad and potentially impinging upon the right to discuss terms and conditions of employment. Now, it also concluded there are certain policies that were acceptable. Policy: any of your conduct that adversely affects your job performance, the performance of fellow associates, or other members, blah, 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 may result in disciplinary action. Okay, that makes sense. Quote, always be fair and courteous to fellow employees, residents, owners, suppliers, blah, blah, blah. Then it says, nevertheless, if you decide to post complaints or criticisms, avoid using statements, photographs, video, or audio that reasonably could be viewed as malicious, obscene, threatening, or intimidating.
Yeah.
That disparage residents, other employees, owners, or suppliers, or that might constitute harassment or bullying. That's a legitimate policy, according to the NLRB.
Yeah. No, I can see that.
And then another one, which I don't think most people do, but do not create a link from your blog, website, or other social networking site to a website without identifying yourself as a company employee. And remember that being a company employee means that you are taking on the responsibility of presenting yourself in a professional manner. Express only your personal opinion. That's okay. It's legitimate policy. And last, this is from their handbook, never represent yourself as a spokesperson for Friendship Ridge. Well, that's reasonable too. So generally, griping and PCA, protected concerted activity.
I'm going to have to write that down. Oh, God.
Let's look at some of the things that we've sort of in summary as we wind down. I may finish this, I may not finish this. I guess all of you are sitting on the edge of your seats.
This has been an
nobody's
informative
calling.
hour, I'll tell you. Well, they don't want to get in the way. This is great.
Complaining to coworkers about the company, its managers, and workplace conditions. It could be just griping and you could be fired. Or it could be PCA and you're protected. We're going to figure out, I'm going to tell you why and how in a moment. Posting negative or disparaging statements about the company's terms and conditions of employment or its treatment of employees on Facebook, Twitter, and other social media. It could be griping or PCA. Discussing terms and conditions of employment such as salary and bonuses, impending promotions and terminations with coworkers and outsiders. Could be griping or PCA. Investigating and asking questions about other employees' terms and conditions of employment. Same thing. Speaking out on behalf of coworkers. Bringing a group complaint to management. And failing to keep non-business sensitive information confidential if it involves an element above. All right. So what's griping and what's PCA? By now, hopefully, if you're listening, you know what PCA is. Protected Concerted Activity. It's really interesting how this is defined. And I have a little bit more to go, and maybe we'll finish it up next week. But just so that you're not hanging on the edge of your seats. If you are seeking comment to your post, engaging in discussion, that is PCA. At least 2 employees engaging in communication about these types of topics is protected concerted activity. If your post is designed not to seek discussion, but is just a complaint. My supervisor is an SOB, a-hole, MF. These are real things, by the way.
Yes, I'm well aware, yes.
You are not protected. You are griping. You are complaining. You're not asking for input or discussing policies or procedures. Now, you want to be a smart person? You can gripe and protect yourself at the same time. And there are cases on this which we will discuss. You can gripe, but openly seek and solicit comment on how to remedy the situation. That may not be your true goal. You may just want to call your employer or your supervisor an SOB. But if you phrase it the right way, you can be protected.
I remember some friends who've done that.
I know you're not going to call a lawyer every time you want to make a Facebook post, otherwise I'd be really rich. But, we're in the 21st century, and you cannot just post things on social media and consider it the Wild West, where there is no law and no boundaries. The courts are assessing boundaries these days. Okay? You can defame on social media and be held responsible. You can complain about your boss, your employer, another employee, and it can be okay. Or you can be fired. Now, there are some overriding principles, but, we don't really have time to finish that discussion right now. I will finish it next week. It won't take very long. I got further than I thought. I do hope that those of you who have been listening have really found this informative, because I am getting lots of calls, and I know other attorneys, from employees who have been fired because of what they post. Sometimes I believe the employer is wrong. Doesn't mean I'm always going to represent you, because it all depends upon how strong it is and how likely I think I'm going to be able to get a settlement or win a case. You don't want to buy a lawsuit. You don't want to get yourself fired. Be careful. As I used to say on one of the TV shows, one of the police shows, be careful out there. Anyway, I'm Stuart Address. That's all for this week. I'll be back next week. You can always call my office at 781-8003 and speak to Sadia. I hope you all have a great weekend and a great week. That's it for Ask a Lawyer. Take care.
Or as you said at the very beginning of the show, just don't do it. This is WPSL, Port St. Lucie. We're talking the Treasure Coast.